Okay, I'd like to begin again with our third lecture for this week. We gave the introduction earlier, and a while ago I posted a lecture from YouTube on kind of competing definitions of disability. And I'd like to connect that now to a discussion about disability policy and disability law. I hope you have a chance to have read through the multiple and at times competing definitions of policy, as well as to have read the disability policy article and the disability law article. I've also posted a PowerPoint on our class folder that'll perhaps help you follow along a little bit better with some of the ideas, both contradicting ideas as well as new and emerging ideas that I'd like for us to discuss over the course of the next 6 weeks. As I mentioned, one of the things that happens in terms of coming up with a definition of policy is there doesn't seem to be a complete agreement in the literature out there. Therefore, one of the things that I want to do is provide us with a definition that we will try and use over the course of the semester. So let me read that to you, and this comes from some work that actually you'll read next week. This policy I define as a set of explicit statements that guide legitimate citizenship status and responses to citizenship status in the form of resource access, allocation, and other action responses to legitimate citizens. As this is a deliberate plan of action to guide decisions and achieve desired outcomes. This, I think, will make a little bit more sense as we begin trying to make application of it. The term policy also, I think, is important for us to understand, and kind of looking to Wikipedia, the term may apply to government, private sector organizations and groups and individuals. And so we experience policy in virtually all aspects of our life, whether we are at work, whether we're at school, whether it's in our faith organizations, wherever we might participate. But for us, for this class, we're really going to specifically focus on that policy which is linked to law, which is why I want to now provide a definition of law. By law, what I mean is that specific legal and enforceable statement of a policy, legal document setting forth rules governing a particular type of relationship. Law really is a system of rules usually enforced through a set of institutions. And here, when we ultimately begin talking about disability, the kinds of laws we might be talking about are laws such as the Americans with Disabilities Act, IDEA, a variety of other laws, and we'll talk about them particularly with respect to the purpose and really thinking about the purpose of disability policy. The purpose of disability policy, as I view it, and one of the ways that I'd like for us to chat about, is to enhance the participation of people with disabilities in communities and access to resources. So those kinds of laws which begin to prevent discrimination, begin to address some of the barriers, or the types of laws, disability policy laws, that detail what kinds of goods and resources and opportunities somebody with a disability might have. I think one of the things, in order for us to look at disability policy in the United States, is really important to see there's been a shift in terms of from a medical treatment to an anti-discrimination protection for people with medical definitions of disability. If we look back to the early history of disability policy in the United States, it largely was in response to returning veterans from World War I, World War II, and those veterans, in terms of providing them with the opportunities and the resources to gain vocational skills so that they could return to what was called productive kind of work. And now what we're seeing is the shift. Clearly at that point in time, people were defined by their medical conditions. Now with things like the ADA, with IDEA, other kinds of laws, we're beginning to address some of the barriers that may have been prohibiting people from participating. And today's policies view society as an institution that has discriminated against those with particular medical conditions. And that really comes directly, and it's a quote from one of the readings for today. Disability policy in the United States really is a mixture of local, community, state, and federal laws, regulations, and court cases. In some of the writing, and actually the reading that you'll do next week, Liz DePoy and I have really defined disability policy even slightly different than some of the other literature. We've defined, and I'll give a definition, we define disability exclusive policy, disability embedded policy, and disability implicit policy. What I mean by that in terms of disability exclusive policy, those are those policies that apply singularly or exclusively to disability, so such as the ADA. So the category of people that the ADA, the Americans with Disabilities Act, applies to are disabled people. When we talk about disability embedded policy, that has a similar function. However, what happens is the category of disability may be one of several categories mentioned. An example there might be the Violence Against Women's Act, which in the Violence Against Women's Act, one of the category populations mentioned are disabled individuals. Other categories might be immigrant populations, non-working populations, etc. The third kind of piece of disability policy that is not often spoken about really is, or not often labeled as disability, is disability implicit policy. What we really mean by that are those laws, rules, regulations that either are designed to prevent disability, designed to prevent harm. There we're really thinking of things like helmet laws that might be in place, seatbelt laws, a variety of the environmental protection laws that guide where and how landfills can be done, so to protect our health. Really, there's been a movement in thinking about policy in terms of disability, from thinking about people in terms of historically disability as a minority or group perspective to more of a civil rights. Earlier on, in terms of this move in a minority group, began to equate people with disabilities with other kinds of disenfranchised or groups that might have been left out of the provision of opportunity. So there really was a focus in terms of equity, legal protections, and a focus upon laws and those experiences out there that might have subordinated people or left people outside of not being able to go to school. A classic example there is IDEA, in terms of we had a variety of school policies that allowed children to go to school, but up until the IDEA came in effect, children with disabilities were not provided a full and equal opportunity to participate in school. We'll spend some time talking about that. There's also been clearly a shift in moving and seeing disability as a social and cultural construct. The kinds of policies, and although I won't talk about those necessarily overtly in this lecture, really is the Rehabilitation Act of 1973 is one that comes up, and that we have defined really as a disability exclusive policy. The primary focus on that being vocational training and rehabilitation. And there's a variety of sections in that really come into play that we need to be aware, but Section 501 deals with affirmative action, which is really kind of important to us. We're all common in terms of thinking about, in terms of public school and post-secondary education, Section 504, which provides that someone, no otherwise qualified individual with a disability shall, solely by reason of his or her disability, be excluded from participation in or denied the benefits or subjected to discrimination under any program receiving federal financial assistance. Now that's critically important for us to think about. That law referred primarily and exclusively to federal assistance. The Americans with Disabilities Act, which built upon that, took that idea and extended it to the private sector. But we still ended up with a medical definition of disability, someone with a physical, mental impairment that substantially limited one or more major life activities, a record of having such an impairment, or being regarded as such an impairment. But Title I of the ADA began to cover non-discrimination in the area of employment. Title II covered non-discrimination to public entities, those services or programs that allowed us or should allow us to be able to participate. And Title III covered non-discrimination in public accommodation, being able to go stay the night at someplace. It really, the other acts that I think that we will talk about during the course of this semester really is the IDEA, or which was originally passed in 1975. I mentioned that earlier as All Handicapped Children Act. And finally, disability embedded policy, the Fair Housing Act amendments, which was passed in 1988, which prohibited housing discrimination against individuals with disabilities. So what I would hope that we would do over the course of this semester is really take an opportunity to look at why and how policy is developed, at who it benefits, as well as who gets left out of the mix, and where and how disability gets put into that, and what is ultimately the definition of disability. Think back to the lecture earlier where we defined the multiple and competing definitions of disabilities, but one of the things that I suspect you'll see is ultimately many of the laws come down to and deal with a medical definition of disability. Look forward to talking to you again soon. Thank you.